I was sitting on my back porch in Raleigh, North Carolina, sipping my morning coffee when I noticed the construction crew rolling onto my property. Not near my property, not beside it. Directly onto the 2-acre lot I owned behind my house on Wilmington Street that I'd been planning to turn into a small orchard someday. My name is Gerald Brennan, and I'd lived in the Meadowbrook community for 8 years. I bought my house and the adjacent lot as a package deal back in 2018, specifically because I wanted the extra space. The lot was clearly delineated on my deed. My property taxes reflected ownership of both parcels, and I had the survey stakes to prove it. I walked down my driveway, coffee mug still in hand, as a dump truck began unloading gravel near the oak tree I'd planted 3 years ago. "Hey," I called out to the foreman, a burly guy in an orange vest. "What's going on here?" He looked up from his clipboard, squinting in the early September sun. "HOA Clubhouse construction should be getting started on the foundation next week." My stomach dropped. "This is private property, my property." The foreman frowned and pulled out a document. "Says here this is community land, Lot 445B, approved by the Meadowbrook HOA Board for recreational facilities." "That's impossible. I own this land. I have the deed." He shrugged with the practiced indifference of someone who dealt with confused homeowners before. "You'll have to take that up with the HOA, buddy. I just build what they tell me to build." I pulled out my phone and immediately called the HOA management office. A chipper receptionist answered, and I demanded to speak with whoever was in charge of this construction project. "That would be our board president, Wendy Patterson," she said. "But she's in a meeting right now. Can I take a message?" "Yes, tell her to get those construction crews off my property immediately or I'm calling the police." There was a pause. "Sir, I'm sure there's just some confusion. Mrs. Patterson will call you back." I hung up, furious. The construction crew had already started setting up equipment, completely ignoring my presence. I went back inside and dug out my property documents from the filing cabinet in my home office. Everything was crystal clear. Lot 445B was mine, purchased alongside my house, legally transferred, taxes paid every year. My phone rang 20 minutes later. The caller ID showed it was Wendy Patterson. "Mr. Brennan, I understand you're concerned about the clubhouse construction," she said in that syrupy sweet voice that middle-aged HOA board presidents seem to perfect. "But I assure you, everything is in order." "Everything is not in order. You're building on my land." "I'm afraid you're mistaken. That lot was designated as community space in the original development plans from 2002. The HOA has every right to develop it for community use. I bought that lot in 2018. I have a deed. I pay property taxes on it." "Well, that seems like an error on the part of the county recorder's office. We have documentation showing that lot was always meant to be HOA property. I'll have our lawyer send you the paperwork." "Your lawyer? I'm the one who should be getting a lawyer." "Get your construction crew off my land today, or I'm taking legal action." Wendy's voice lost some of its sweetness. "Mr. Brennan, I'd advise you not to threaten the HOA. We have a substantial legal fund, and we don't take kindly to residents who try to interfere with community improvements. The clubhouse is happening. We've already invested over $100,000 in planning and permits. On my property. On community property," she corrected. "Good day, Mr. Brennan." She hung up before I could respond. I spent the rest of the morning on the phone with a real estate attorney named Marcus Chen, who came highly recommended by a colleague. I explained the situation, sent him photos of my deed and property survey, and he agreed to review everything. "This sounds pretty straightforward," Marcus said. If you have a clear deed and the property is registered in your name with the county, the HOA has no claim to it. I'll send them a cease and desist letter today. They said they have documentation from the original development. Doesn't matter. You purchased it legally. Even if there was some original intention for it to be community space, the moment it was sold to you as private property, that changed everything. Let me handle this. I felt slightly better after hanging up with Marcus, but the construction crew was still out there, now digging holes for what looked like foundation posts. I went back outside and took extensive photos and videos, documenting everything. By that afternoon, I'd contacted the county planning and zoning office to inquire about the construction permits. A helpful clerk named Sharon looked up the information. Yes, I see a permit here for a clubhouse at that address, issued to Meadowbrook HOA, she said. Approved on August 3rd. Based on what property documentation? I heard her typing. It shows the applicant provided proof of ownership through the HOA charter and development agreement. But I own that property, individually. Can you put a stop work order on it? I'm afraid I can't do that without evidence of a dispute. If you believe there's an error in the permit, you'll need to file a formal complaint and provide your documentation. We'll investigate, but that takes time. How much time? Usually 4 to 6 weeks. I groaned. They could have the whole foundation poured by then. I understand your frustration, sir, but we have to follow procedure. I filed the complaint immediately, uploading digital copies of my deed and survey. Marcus sent the cease and desist letter to the HOA that same day. I thought surely that would slow things down. I was wrong. The next morning, not only was the construction crew back, but they'd brought in a concrete truck. I called Marcus in a panic. They're pouring the foundation right now. Stay calm. I'm filing for a temporary restraining order today. We'll get this in front of a judge as soon as possible. When is that? Hopefully within the week. I couldn't just sit there and watch them build on my land. I drove straight to the Meadowbrook HOA office, a small building near the community pool. Wendy Patterson was sitting at the front desk, sorting through papers. She looked up as I walked in, her expression hardening. Wendy was exactly what you'd imagine when you heard the words HOA board president. She had that asymmetrical blonde bob that seemed mandatory for women in positions of petty authority, oversized sunglasses perched on her head despite being indoors, and a visible annoyance at being interrupted. Mr. Brennan, I thought we settled this. You're ignoring my attorney's cease and desist letter. Our attorney reviewed it and determined it has no merit. The construction continues. I own that land, Wendy. This isn't a gray area. She stood up, crossing her arms. The HOA has invested significant resources into this project. We held community meetings, took votes, hired architects. The clubhouse will include a fitness center, a community room, and a catering kitchen. It's a $450,000 project that will benefit the entire neighborhood. On my property. On what you mistakenly believe is your property. Our records clearly show. I don't care about your records. I have a legal deed filed with Wake County. You can't just decide my property is yours because you want to build something on it. Wendy's lips pressed into a thin line. The board has voted. The clubhouse is being built. If you continue to interfere, we'll have no choice but to pursue legal action against you for harassment and interference with community operations. I couldn't believe what I was hearing. You're threatening to sue me for trying to protect my own property. I'm advising you that your actions have consequences. Now I have work to do. Please leave. I wanted to argue more, but I knew it was pointless. Wendy had that self-righteous certainty of someone who'd convinced herself she was doing the right thing. Facts be damned. I left the office and headed straight back to my attorney's. Marcus was already preparing for the emergency hearing he'd scheduled for the following Tuesday. "This is one of the most clear-cut property disputes I've ever seen," he said, spreading my documents across his conference table. "You have an unambiguous chain of title. The county records show you as the owner. They're literally committing trespass and property damage. So why are they so confident? Arrogance, mostly. HOAs sometimes think they're above property law because they're used to enforcing their own rules, or they're relying on some outdated documentation that was superseded when the lot was sold. Either way, they're wrong." The hearing couldn't come fast enough. In the meantime, the construction continued at an aggressive pace. By Monday, they'd poured the entire foundation and were framing walls. I documented everything, took time-stamped photos, and tried to control my rising blood pressure. Tuesday morning, I met Marcus at the Wake County Courthouse. We were ushered into a courtroom where Judge Raymond Mitchell would hear our motion for a temporary restraining order. Wendy Patterson was there with the HOA's attorney, a slick-looking guy in an expensive suit named Trevor Hastings. Judge Mitchell, a stern man in his 60s with silver hair, reviewed the submitted documents before calling the hearing to order. "Mr. Chen, you're requesting an immediate halt to construction based on a property ownership dispute," Marcus stood. "Yes, Your Honor. My client, Mr. Brennan, owns the parcel in question, Lot 445B. He purchased it legally in 2018, has paid property taxes on it, and has a clear deed. The HOA began construction without his permission, ignoring his cease and desist letter." Trevor Hastings stood up. "Your Honor, if I may. The Meadowbrook HOA has documentation from the original 2002 development agreement showing that Lot 445B was designated as community space. Any subsequent sale of that property was done in error and should be voided." Judge Mitchell frowned. "You're arguing that a legally recorded property sale should be voided because of a 24-year-old development agreement." "We're arguing that the sale itself was improper, Your Honor. The HOA never relinquished its claim to that property." "Do you have documentation showing the HOA owned the property at the time of the 2018 sale?" Hastings hesitated. "We have the development agreement showing the lot's intended use." "That's not what I asked. Did the HOA hold title to the property in 2018? The title situation was complicated, Your Honor." Judge Mitchell looked at the documents in front of him. "It looks pretty straightforward to me. The property was owned by Meadowbrook Development Corporation, which sold it to Mr. Brennan in 2018. Where does the HOA's ownership claim come from?" "The development agreement stipulated, Mr. Hastings. A development agreement about intended use doesn't override actual property ownership. If the development company sold the lot to Mr. Brennan and that sale was properly recorded, then he owns it." "Do you have any documentation showing the HOA held title to this property?" Hastings shuffled through his papers. "We're working on obtaining those records, Your Honor." "So that's a no." Judge Mitchell turned to Marcus. "Mr. Chen, I'm granting your temporary restraining order. All construction on Lot 445B is to cease immediately pending a full hearing on the property ownership question. We'll schedule that for—" He checked his calendar. "October 15th. That gives both parties time to gather their documentation and evidence." I felt a wave of relief wash over me. Wendy Patterson's face had turned red, and she whispered furiously to Hastings. "Your Honor," Hastings said, "the HOA has already invested substantial funds in this project. A work stoppage will result in significant financial harm." "Then the HOA should have verified property ownership before breaking ground," Judge Mitchell said dryly. "The restraining order is granted. Bailiff will provide the order documentation. Court adjourned." As we left the courtroom, Wendy caught up with me in the hallway. Her face was flushed with anger. "You're making a huge mistake," she hissed. "The HOA will fight this and we will win. You'll end up paying our legal fees on top of your own. Wendy, you built on my property without permission. You're lucky I'm not pressing criminal charges for trespassing and vandalism. We'll see who's pressing charges when this is over," she snapped, then stormed off. Marcus put a hand on my shoulder. "Don't engage with her. Let the legal process work." The construction stopped that afternoon, though not without drama. The foreman called Wendy, who apparently threw a fit before finally authorizing the work stoppage. The half-built structure sat there like a monument to HOA overreach, visible from my back porch. Over the next few weeks, I dug deeper into the history of my property. I discovered that Meadowbrook Development Corporation had indeed planned to reserve Lot 445B for community use back in 2002. However, when the development hit financial trouble during the 2008 recession, they'd sold off several reserved lots to stay afloat. Mine was one of them. The lot had gone through 2 owners before I purchased it in 2018. Each sale was properly recorded, taxes were paid, and there was never any indication of HOA ownership or claim. The HOA had simply assumed the lot was still theirs because it had been designated that way in the original plans. Marcus subpoenaed the HOA's records and discovered something interesting. Back in 2010, when my lot had first been sold by the development company, the HOA board at that time had actually discussed the issue. The meeting minutes showed they'd consulted with an attorney who told them they had no legal claim to the property since they'd never owned it. The development company had owned it, and the development company had the right to sell it. The HOA had accepted this and moved on. Until Wendy Patterson became board president in 2023. Wendy, I learned, had been pushing for a clubhouse since she took office. She'd convinced the board that the neighborhood needed a central gathering space, somewhere to hold events and meetings. When she'd looked at a map of the community and seen Lot 445B listed on an old 2002 development plan as Future Community Center, she'd apparently decided that meant it was HOA property. She'd never bothered to check the actual property records. She just assumed. And when I'd produced proof that I owned the land, rather than admit the mistake, she doubled down. The HOA had spent over $130,000 on architectural plans, permits, and initial construction before I'd even known what was happening. Now, faced with the reality that they'd messed up, Wendy was determined to find some legal loophole to justify the construction. She couldn't afford to admit she'd led the HOA into a 6-figure mistake based on her own failure to do basic due diligence. The October 15th hearing approached. Marcus was confident, but he warned me that courts could be unpredictable. "We have the facts on our side," he said. "But Hastings is going to argue that you somehow should have known the HOA might want the property, or that there's some equitable claim based on community expectations. It's nonsense, but we need to be prepared." The night before the hearing, I got a call from an unknown number. I answered cautiously. "Mr. Brennan, this is David Kowalski. I'm on the HOA board." "Okay. I wanted to call and apologize. I voted for the Clubhouse project, but I had no idea Wendy hadn't verified the property ownership. When I found out we were building on your land, I confronted her about it. She told the board you were being unreasonable and that our lawyers said we'd win in court. Your lawyers are wrong." "I know. I looked at the documents myself. I'm not a lawyer, but I can read a property deed. You clearly own that land." He sighed heavily. I've tried to convince the other board members to drop this and apologize, but Wendy has them convinced that backing down would make the HOA look weak. David, the HOA already looks weak. You built a clubhouse on someone else's property. I know. I'm actually planning to resign from the board after this is over. I just wanted you to know that not everyone supports what's happening. And I think you should know that Wendy is planning something. My stomach tightened. What do you mean? I overheard her on the phone with Hastings yesterday. She's trying to get testimony from neighbors saying that everyone always understood that lot was for community use, that you should have known you couldn't develop it privately. She's trying to build a case for some kind of implied easement or community expectation claim. That's absurd. I can use my own property however I want. I agree. But she's desperate. She took out a loan against the HOA's reserves to fund this clubhouse. If the project fails, the HOA is going to be in serious financial trouble, and it'll be her fault. She'll probably be voted out, maybe even sued by other homeowners. So she's doubling down instead of cutting her losses. Exactly. Just be prepared for her to fight dirty tomorrow. I thanked David for the warning and called Marcus to fill him in. He wasn't surprised. Let her try, he said. Community expectations don't override property rights. She can parade 100 neighbors in there saying they thought the lot was community space. It doesn't change the fact that you legally own it. The hearing the next day was standing room only. Apparently word had spread through the neighborhood, and dozens of residents showed up to watch. I recognized several neighbors, some nodding sympathetically to me, others glaring like I was the villain in this story. Judge Mitchell called the proceedings to order and invited Hastings to present the HOA's case. Hastings stood, confident as ever. Your Honor, while it's true that Mr. Brennan holds a deed to Lot 445B, we believe there are compelling reasons why the construction should be allowed to continue. First, the property was always intended as community space according to the original development plans. Second, the community has operated under the reasonable expectation that this land would be used for community purposes. Third, the HOA has invested nearly $450,000 into this project, which would represent significant financial harm if abandoned. Judge Mitchell raised an eyebrow. $450,000. I thought construction just started. The total project budget is $450,000, Your Honor. To date, we've spent approximately $130,000 on planning, permits, and initial construction. Still a considerable sum to spend without verifying property ownership. Hastings cleared his throat. The HOA relied on historical documents and reasonable assumptions based on 20-plus years of community understanding. Mr. Hastings, assumptions are not title searches. Continue. Hastings called several witnesses. First was Wendy Patterson herself. She took the stand wearing a navy blue dress, suit, and pearls, looking every inch the concerned community leader. Mrs. Patterson, can you explain how the clubhouse project came about? Hastings asked. Certainly. I've been board president for nearly 3 years, and during that time, residents have repeatedly requested a central community space. We don't have anywhere to hold neighborhood meetings, holiday parties, or fitness classes. We surveyed the community, and over 70% of respondents supported building a clubhouse. And how did you select the location? We reviewed the original development plans and found that Lot 445B was designated for community use. It seemed like the perfect location, central to the neighborhood with easy access. Did you verify ownership of the property? We reviewed the HOA's charter and the development agreement from 2002. Everything indicated that lot was community space. Marcus stood up. Objection, Your Honor. The witness is not a legal expert qualified to interpret property documents. Sustained. Mrs. Patterson, stick to what you personally did and observed. Wendy nodded. We hired an architect, held community meetings to discuss the design, and once we had board approval and community support, we filed for the necessary permits. Did the county raise any issues with your permit application? No, they approved it without any problems. Hastings smiled. No further questions. Marcus stood for cross-examination. Mrs. Patterson, did you conduct a title search on Lot 445B before beginning construction? Wendy hesitated. I relied on the documents provided by our management company. That's not what I asked. Did you personally, or did you direct anyone, to conduct a formal title search to verify ownership? No, but yes or no, please. No. Did you check the county property records to see who was paying taxes on Lot 445B? No. Did you contact Mr. Brennan to discuss using the property before you began construction? We didn't believe we needed his permission. Because you assumed you owned it. Because the development plans clearly showed it as community space. Marcus picked up a document. Mrs. Patterson, I'm showing you what's been marked as Exhibit C, which is the meeting minutes from a June 2010 HOA board meeting. Can you read the highlighted section? Wendy took the document, her face paling slightly. It says, Board discussed Lot 445B sale by development company. Attorney Miller advised that HOA has no ownership claim. Board accepted this and moved on. So the HOA knew in 2010 that it didn't own Lot 445B. That was a different board. I wasn't president then. But these are official HOA records. You have access to them, correct? Yes. Did you review the board's historical records before beginning a $450,000 construction project? Wendy's jaw tightened. I reviewed the relevant documents. Apparently not all of them. No further questions. Hastings called a few neighbors who testified that they'd always assumed the lot was for community use, that they'd seen it marked as such on old neighborhood maps. Marcus challenged each one, establishing that none of them had any actual knowledge of who owned the property. They just made assumptions. Then it was our turn. Marcus called me to the stand. Mr. Brennan, when did you purchase Lot 445B? In 2018, as part of a package deal with my house. Were you aware of any HOA claims to the property at that time? No. The title company did a full search. There were no liens, no encumbrances, no claims of any kind. The seller had clear title and they transferred it to me. What were your plans for the property? Eventually, I wanted to plant fruit trees, maybe put in a small orchard, but mainly I just wanted the extra space and privacy. When did you first learn about the clubhouse construction? The morning they showed up with equipment and started clearing the land. I confronted the foreman, who told me the HOA had hired him. I immediately contacted the HOA to tell them they were on my property. What was their response? Wendy Patterson told me I was wrong, that the HOA owned the land, and that construction would continue regardless of my objections. Marcus walked me through the timeline, the cease and desist letter, Wendy's threats, everything. Then Hastings cross-examined me. Mr. Brennan, you've lived in Meadowbrook for 8 years, correct? Yes. In that time, did you ever attend HOA meetings? A few early on. Did you ever hear discussions about wanting a clubhouse? I might have. I don't recall specifically. But it's fair to say the community desire for a clubhouse was well known, I suppose. And yet, when you saw Lot 445 be marked on old development maps as community space, you never thought to clarify your ownership status with the HOA, I frowned. I never saw any such maps, and I didn't need to clarify anything. I own the property. It's on my deed. But you knew the community wanted a clubhouse and you had a large vacant lot. Didn't you think the two might be connected? Why would I? It's my property. What the HOA wants is irrelevant to what I do with my own land. Hastings gave me a patronizing smile. So you're saying you had no idea the community might have expectations about that lot? Marcus objected. Relevance, Your Honor. Community expectations don't override property ownership. I'll allow it, but make your point, Mr. Hastings. Mr. Brennan, if you'd known the community expected to use that lot, would you have been willing to discuss selling it to the HOA or granting an easement? If they'd asked me before building on it, maybe we could have had a conversation, but they didn't ask. They just assumed they could take it. No further questions. After testimony concluded, both attorneys gave closing arguments. Hastings argued that the HOA had acted in good faith based on reasonable historical expectations, and that forcing them to tear down the partially completed clubhouse would cause irreparable financial harm to the community. Marcus countered that good faith doesn't excuse trespassing, and that the HOA's financial problems were self-inflicted consequences of their failure to do basic due diligence. Judge Mitchell took a brief recess, then returned with his decision. "This is not a complicated case," he began. "Mr. Brennan holds clear, unencumbered title to Lot 445B. The HOA does not. The HOA's claims based on historical development plans, community expectations, or good faith assumptions are legally insufficient to override Mr. Brennan's property rights. The HOA built a structure on someone else's land without permission. That's trespassing and property damage, no matter how good their intentions were. The restraining order is made permanent. The HOA must immediately cease all construction activities on Lot 445B. Furthermore, Mr. Brennan is entitled to remedies for the damage to his property. The parties will work out either voluntary removal of the structure by the HOA or compensation to Mr. Brennan for the diminished value of his property. If you can't reach an agreement, we'll have another hearing to determine damages. I strongly encourage the HOA to settle this matter quickly and quietly. You've already spent enough money on this mistake. Don't compound it with further litigation you cannot win." The gavel came down. I felt like a massive weight had been lifted off my shoulders. Wendy Patterson looked like she'd been slapped. She gathered her things quickly and left without making eye contact with anyone. Outside the courtroom, Marcus shook my hand. "Congratulations. Now we need to figure out what you want to do about that half-built clubhouse on your property. I want it gone. They might offer to buy the land from you. I thought about that. At this point, I don't think I want to sell to them. They've been so nasty about this whole thing." "That's your choice. Let me reach out to Hastings and see what they propose." Over the next week, the HOA's position crumbled. David Kowalski made good on his word and resigned from the board. 2 other board members followed him, leaving Wendy scrambling to maintain a quorum. Hastings called Marcus with a settlement proposal. The HOA would pay for complete removal of the structure and restoration of the land to its original condition, plus $15,000 in compensation for my trouble and legal fees. "It's not enough," I told Marcus. "They damaged my property, ignored my legal rights, threatened me, and put me through months of stress. What do you want?" "I want them to pay for a proper survey and fence installation around the entire property so this never happens again. And I want $50,000 in compensation, plus my actual legal fees." Marcus negotiated back and forth. The HOA balked at $50,000, claiming they couldn't afford it. Marcus pointed out that they'd somehow found $450,000 for a clubhouse, so they could find money to settle the lawsuit they were guaranteed to lose. We eventually settled at $35,000 plus legal fees, complete removal and restoration, and the survey and fence. The HOA would also issue a formal written apology to be included in the next community newsletter, along with an explanation of what had happened so other homeowners would know the truth. Wendy Patterson fought the settlement tooth and nail. But with half the board gone, and the remaining members facing potential personal liability for continuing to defend the indefensible, they overruled her and voted to accept. The demolition started in early November. A crew spent 2 weeks dismantling the partial structure, removing the foundation and restoring the ground. They brought in new topsoil, reseeded the grass, and left it looking better than before the construction started. I thought that would be the end of it. I was wrong. In late November, I got a call from Sharon at the county planning office. "Mr. Brennan, I wanted to give you a heads up. We've completed our investigation into the permit that was issued for the clubhouse construction." Okay, there were some irregularities. The HOA's permit application included a document purporting to show HOA ownership of the property. That document appears to have been altered. My pulse quickened. Altered how? Someone took the old 2002 development agreement and modified it to remove language indicating the property could be sold. They made it look like the lot was permanently designated as HOA property. It's pretty sophisticated, but our forensic examiner caught it. Are you saying the HOA submitted fraudulent documents to get the permit? That's what it looks like. We're referring this to the district attorney's office. I thought you should know. I immediately called Marcus. He was equally shocked. If they knowingly submitted altered documents, that's fraud. That's criminal. Who would have done that? Whoever prepared the permit application. Do you know who that was? I didn't, but I suspected. Marcus filed a motion to get the permit application documents, and we discovered that Wendy Patterson had personally submitted the application and signed the declaration that all attached documents were true and accurate. The forensic examination of the altered document revealed something else interesting. The modifications had been made digitally, and the metadata showed the file had been edited on a computer registered to Wendy Patterson just 3 days before the permit application was submitted. She'd done it herself. The Wake County District Attorney's Office opened an investigation in December. I was interviewed, as were several HOA board members. David Kowalski told investigators that Wendy had handled the permit application personally, saying she wanted to streamline the process and didn't need board approval for administrative tasks. She'd lied to the board about verifying ownership, then falsified documents to trick the county into issuing a permit, all to avoid admitting she'd screwed up. In January, Wendy Patterson was charged with 2 counts of forgery and 1 count of uttering a forged instrument. The charges were serious felonies, carrying potential prison time. The news spread through Meadowbrook like wildfire. I started getting apologetic messages from neighbors who'd sided with the HOA during the dispute. Several told me they'd had no idea Wendy had forged documents. They genuinely believed the HOA owned the land because that's what Wendy had told them. The HOA held an emergency election and installed a new board president, a retired accountant named Helen Morrison, who seemed determined to restore the organization's reputation. She reached out to me personally to apologize. "What Wendy did was unconscionable," Helen said when we met for coffee. "She betrayed the trust of every homeowner in this community. I want you to know that the new board is committed to transparency and following the law." I appreciate that. I also want to ask if you'd be willing to consider selling Lot 445B to the HOA, at a fair market price, of course. The community really does want a clubhouse, and that lot is still the ideal location. I'd thought about this. My anger had cooled, and I could see that the clubhouse itself wasn't a bad idea. It was just the way Wendy had gone about it that was so wrong. Let me think about it, I told Helen. Wendy's case went to trial in March. Her attorney tried to argue that she'd made an honest mistake, that she'd believed the document was accurate. But the forensic evidence was damning. The prosecutor showed that she deliberately altered a historical document, submitted it to the county knowing it was false, and then lied to her own board about what she'd done. The jury deliberated for less than 3 hours before finding her guilty on all counts. At sentencing in April, the judge noted that Wendy had violated the public trust and abused her position of authority in the community. She was sentenced to 18 months in prison, 3 years of probation, and ordered to pay restitution to the county for the cost of the investigation and to me for additional damages beyond the civil settlement. I didn't attend the sentencing. I'd moved on. After thinking it over for several weeks, I decided to sell Lot 445B to the HOA. Not because I had to, but because I realized Helen was right. The community did want a clubhouse, and my plan to plant an orchard had never gotten beyond the planning stage. I wasn't using the land, and selling it would give me a nice financial cushion. We negotiated a fair price, $85,000, which was above market value but reflected the lot's particular value to the HOA. The sale closed in May, and the HOA immediately began working on new plans for a clubhouse. This time, they hired a professional project manager and actually verified that they owned the property before breaking ground. The new clubhouse design was more modest than Wendy's grandiose vision, budgeted at $250,000 instead of $450,000. It included a community room, a small fitness area, and a kitchenette. Groundbreaking was scheduled for July, pending all the proper approvals and permits. I used part of the money from the land sale to take a long vacation to Ireland, something I'd been putting off for years. When I got back in late May, construction on the clubhouse was just beginning. This time, I watched from my porch with satisfaction instead of fury. Helen stopped by one evening while I was grilling dinner. "I wanted to thank you again for selling us the land," she said, "and for not holding Wendy's actions against the whole community. Wendy made her own choices. The rest of you shouldn't have to pay for them forever. Still, you could have made this much harder. You had every right to be angry. I was angry, but staying angry doesn't help anyone. The community gets their clubhouse, I got fairly compensated, and Wendy is facing the consequences of what she did. That's about as good an outcome as we could hope for." Helen smiled. "You're a better person than I would have been. If someone had built on my land and then forged documents to cover it up, I don't think I'd be so forgiving." "I'm not forgiving her," I clarified. "What she did was wrong, and she deserved to be prosecuted. But I'm not going to let her actions poison my relationship with my neighbors or this community. She doesn't get that power over me." The clubhouse was completed in October, almost exactly a year after Judge Mitchell's original ruling. The HOA held a grand opening celebration, and they invited me as the guest of honor. I declined the special recognition but did attend the event. It was a beautiful fall day, and the new clubhouse looked great. Modest but well-designed, it fit naturally into the neighborhood. Kids were running around on the lawn, neighbors were chatting and eating barbecue, and there was a genuine sense of community pride. David Kowalski found me near the food tables. "Hard to believe where we were a year ago, huh? It's been quite a journey. I'm glad it worked out. And I'm glad you sold them the land. I know you didn't have to." Like I told Helen, no point in holding grudges. Still, not everyone would have been so reasonable, especially after everything Wendy put you through. I shrugged. Wendy's in prison. The HOA is under new management. I got paid fairly for my land. The community got their clubhouse. Everyone won except the person who deserved to lose. Justice, David said, raising his beer. Justice, I agreed, clinking my bottle against his. I stayed at the celebration for a couple of hours, chatting with neighbors and touring the new facility. The community room was spacious and bright, perfect for meetings or parties. The fitness area was small but well equipped. The kitchenette would make catering events much easier. As I was leaving, Helen caught up with me. Gerald, wait, I have something for you. She handed me a framed certificate. It read, "Presented to Gerald Brennan with gratitude for his patience, understanding, and generous spirit. Your willingness to work with the community made this clubhouse possible. Thank you for being the kind of neighbor everyone hopes to have." It was signed by the entire HOA board and dozens of community members. I was genuinely touched. You didn't have to do this. Yes, we did. You had every right to tell us to go to hell and never speak to us again. Instead, you gave us a second chance. That means something. As I walked home that evening, certificate under my arm, I reflected on the whole bizarre experience. A year ago, I'd been furious, violated, ready to go to war with my HOA over their outrageous trespass. I'd been right to fight back, right to demand justice. But I'd also learned something about choosing your battles and knowing when to let go. Wendy Patterson had made terrible decisions driven by pride and stubbornness. She'd refused to admit her mistake, and that refusal had cost her everything, her reputation, her freedom, her future. I could have let anger consume me the same way. I could have refused any settlement, demanded maximum damages, fought the HOA at every turn just to punish them for what Wendy had done. Some people would say I had every right, but what would that have accomplished? More legal fees, more stress, more bitterness poisoning my daily life. The HOA would have remained hostile, my neighbors divided, and the community worse off. Instead, I'd stood up for my rights, won my case, and then chosen to move forward. Not forgiveness for Wendy, because what she did was unforgivable, but a willingness to separate her actions from the community as a whole. The clubhouse stood as a monument to both the danger of unchecked HOA power and the possibility of redemption, when good people take responsibility for mistakes. As for Wendy Patterson, she'd serve her time and hopefully learn that shortcuts and lies always catch up with you eventually. Property rights matter. The law matters. And when you're caught red-handed falsifying documents to build on someone else's land, no amount of righteous indignation or community spirit will save you from the consequences. I hung the certificate in my home office, right next to my property deed for the house. Every time I looked at it, I'd remember the year I fought my HOA and won, not just in court, but in restoring a sense of trust and community that Wendy had nearly destroyed. The clubhouse was finished, Wendy was in prison, and I was at peace. Sometimes justice takes time, but when it arrives, it's worth the wait.